First up today, though, let's talk about men sitting in Australian jails right now who have been convicted of serious terrorism offences, including planning terrorist attacks in this country, and who are due from release from jail this year. We have special laws that could be used to keep them behind bars, but how difficult will this be? I'm joined now by former New South Wales Supreme Court Judge Anthony Whealy in the Sydney CBD. Thanks for joining us, Anthony. I want to first ask you about one of the cases you were involved in. This was the Pendennis case. It related to activities of 2005. The sentencing occurred in 2009. You sent 9 people to jail. They were planning terrorist attacks in Australia. Now, you sentenced 9 people to jail then over such serious allegations, serious offences. You would have expected, of course, at some stage they're going to walk free.
Yes, I put a determinate sentence upon each of them. The most serious sentence was 28 years with a non-parole period, I think, of 24 years. And the others were slightly less than that, but they were very extensive sentences.
And this was because they were planning to do harm to Australians, planning terrorist attacks to kill Australians.
We never knew exactly what the targets of the attacks were likely to be. There was speculation about that, but there was no real evidence to show exactly what they were going to do. But certainly, at the very least, they were going to cause extensive damage to property. And of course, that type of damage, explosions and the like, carry with it the high degree of likelihood that people would be injured or even killed.
Now, does it concern you then that these people who were then motivated by Islamist terrorist ideals, does it concern you then that some of them are due for release this year?
Well, I don't think any of the men that I sentenced are. I think the one that attention is focused on is Bembricker, who was the leader of the Pendennis group, but he was involved from Melbourne and he was sentenced by a Melbourne judge. So I think his day of reckoning is coming fairly soon. The others have some years to go yet. But that's the one that's focused everybody's attention.
Yeah, and what is your view then about the fact that their sentences will come to an end and they'll be set free? Is it possible, is it plausible, given their motivations, that they will have reformed in prison?
Well, I suppose when you sentence somebody to prison, particularly for offences of this kind, you hope that they will be reformed and rehabilitated and that they will be, in effect, deradicalised. But experience tells us from around the world that can often be a forlorn hope because this is a religious conviction of a fanatical kind and very different from the ordinary criminal. And so it's hard for these people to be changed or altered. So, yes, there's always the fear that when their sentence is coming to an end, they will not have recanted, they will not be rehabilitated, and they may, in fact, in an extreme case, pose an unacceptable risk to the community.
Now, we've seen that threat play out in other countries, of course, and in Australia, anticipating this difficulty, there are laws in place to issue continuing detention orders. So some of these terrorists, the ones you've sentenced beyond this year, others who are due for release this year, there are about 10 due for release this year. Would your expectation be that authorities, whether they be the federal police, state police forces, even ASIO, would be involved in trying to get these continuing detention orders?
I think that the federal authorities in particular would be very concerned to look very carefully at each person as their term comes towards an end, and if they feel that these people pose an unacceptable risk to the community, and that means in practical terms, if there's a high degree of probability that upon release they'll carry out a serious terrorism offence, then they will certainly wish to make an application to the court for a continuing detention order.
Now, which court will make that decision? What's the threshold that they have to pass to keep someone in jail indefinitely?
It'll be the Supreme Court of the particular state who will deal with it. The Supreme Court exercises federal jurisdiction in these matters, and the court, as I've said, will only make an order if it's satisfied that there is an unacceptable risk to the community. And the practical approach that will be taken is to determine whether, upon carefully gathered evidence, there is a high degree, I stress that, a high degree of probability that the defendant will commit a serious terrorism offence upon his release.
Yeah, presumably...
So it's a high...
it's a high bar.
High barrier.
Yeah, I was just going to ask you a bit more detail about that, because presumably the person who's due for release would be entitled to representation. So it's almost another court case about the status of their intent.
Of their mind, really, yes. What's in their mind? That's exactly what it is. But don't forget that they will have been examined pretty carefully by psychiatrists, etc., in the prison system. These are government psychiatrists. Their day-to-day behaviour will have been observed by the correctional authorities. There'll be very careful records kept of who they're mixing with, of who they've communicated with. And I think that that does enable the authorities to present a pretty significant dossier in an appropriate case. You know, as I've said, Chris, I mean, we all hope that these people would be rehabilitated. If they've been in jail for 15 or 20 years, you know, God, we want them to be released if that's at all possible. But if the community's in danger, then these new laws passed in 2016 are very effective in stopping anything terrible happening out in the community.
Yeah, I mean, I agree with you. Of course, we would all want these people to reform, but experience here and overseas is that people can actually become radicalised in jail, and that other people can maintain their terrorist or ideological leanings and then attack people when they're released. The most recent attack in London being an example of this. Are you satisfied then from a sort of civil liberties point of view that this is okay? Because a lot of people are going to be saying they've committed an offence, they've served their sentence, they're due for release, and that it is unfair to try and keep them in jail indefinitely.
Well, I would say three things. First of all, yes, it's a harsh law. I accept that. But secondly, I think that in this instance, the protection of the community is the important thing. And, you know, a sentencing judge who sentences somebody to jail for 20 years, he's got no idea what that person will be like at the end of the 20 years. And this system will enable that state of mind to be explored very thoroughly. And the final thing I would say about it all is that if a continuing detention order is made, it's not a further punishment for the crime that's been committed. That crime was given a sentence, the sentence has been served. But what it is it's an order that incapacitates someone who poses a threat to the community, and I think the community really needs that protection. Yeah,
I think they'll be glad to see it. Just briefly, has it been tested yet? I know there's one person convicted of terrorist-related offences released already this year. Paul Maley has listed there are 10 due to be released this year. Do you know whether there's been any applications that have either failed or been successful under these laws yet?
Not in recent times, but I believe that there have been, at state level, a number of interim orders made. You can have, you know, orders for up to 3 years, but the court can even make an order for 6 months to see how things go. So yes, there have been those kinds, but there haven't been any major orders made, I would say.